Okay, so now we have to kind of go with, well, what's going to happen after that? So when the court agrees to grant cert, the next step is going to be that they're going to, the lower courts are going to send all of the records up, and now those poor overworked clerks, their second job, they have to weed through all of those records, and they have to read, and they have to prepare, and at some point, the court is going to schedule what's called oral argument. An oral argument is when each side, unless it's a special case, they get 30 minutes before the justices. And I have to tell you, seeing oral arguments for the Supreme Court, like one of my top 10 lifetime experiences. It was amazing. So what happens is the justices basically get up there, they sit up at the front of the room, and the attorneys get up there, and they have a plan, like they have things that they want to say, but understand the justices already know what's going on. Like they've decided to hear the case, their clerks have read through the records, they've poured over the records. Many of the justices say they go into oral argument kind of already with an opinion based on just what they've read. Some don't, and it's real interesting to kind of watch their thought processes. And so you'll find that like Justice Thomas doesn't talk. He's talked once, I think, from the bench ever. He just doesn't. And he sits there and he has his hands on his belly and he just rocks and he listens, and you can see that he's very he's listening. But even he said usually I already have an opinion, so oral argument doesn't matter as much to me. Whereas Justice Kennedy, it matters a lot, and you can really see that he is paying a lot of attention. He is also considered our swing justice. What do you think that means? Yeah, you never know how he's going to decide. His record, he is not super consistent in voting with one side or the other. Whereas there's certain justices that you always know because there's such continuity to how they vote that it's not so much case by case. So this is a kind of an interesting little video clip. Chief Justice Roberts, prior to being on the court, obviously was an attorney. So he's going to talk about the importance of oral argument, what it was like when he was an attorney, and now as a justice.
Do you remember your first oral argument?
Oh, sure, yes, absolutely. A case called United States against Halper. I was very nervous, but I was very nervous when I did my last oral argument as well. I think if you're a lawyer appearing before the Supreme Court and you're not very nervous, you don't really understand what's going on.
This is a question for all the members of the bar out there, I guess, and for all those attorneys who eventually find themselves lucky enough to have a case before the court. What is it that you wish you had known about the process when you were on that side that you now know?
Everybody tells a lawyer in that position, you have to answer the questions. Don't try to avoid the questions or distinguish your case in any way. I hope I did that when I was a lawyer, but the importance of that is very accentuated. I appreciate it so much more now that I'm on the other side of the bench. You have to appreciate that the justices are engaged in the process of trying to help themselves decide the case correctly. So they're going to ask hard questions. They're going to ask questions that don't put your case in the best possible light, and you need to appreciate that. It's good to establish, I think I didn't appreciate this as much as I should have, some dispassion. Yes, you want to have a certain level of zeal and commitment to your client's cause. The justices know that. But when they ask you a question about a difficult case, it's better to sometimes say, I appreciate that case doesn't support my side. I appreciate that causes us some difficulty. Here's why I think you shouldn't rely so heavily on that case, as opposed to as soon as they ask us, no, that case doesn't hurt us at all, and here's why. They like you to be part of the process that is helping them come to the right result. They understand you've got a client to represent, and they expect you to do that. But if you can convince them that you're on their side in helping them reach the right decision, as opposed to something they have to push against to get you to give an answer, I think that's very helpful, not only to the court, but also to your client.
So after oral arguments are heard, then some months down the line, the court's going to issue a decision. There are 3 kinds of decisions that the court can issue. Decisions come along with writing. you can theoretically, every justice can write a decision. So the decision is not just a yes or a no, or I vote for this side or I vote for that side. It's like a paper, basically. It's an essay where they provide you some legal reasoning. So if the Chief Justice is in the voting majority, then he or she gets the opportunity to write the majority opinion, or they can delegate it to someone else. The Chief Justice's vote does not count more than anyone else's. It's simply they're kind of like the manager of the court, so they kind of get to set the tone for how it's going to be done. And the majority opinion just represents the winning side. And there are currently 9 justices. If all 9 participate, you can have a 5-4 decision. That's fine. You can have 6-3. You can have 9-0. Doesn't matter. Not all. So we don't currently have 9, obviously, because we have a vacancy on the court. So if we have a 4-4 vote, you don't really get to have a majority because nobody got a majority. So there's really no resolution, basically. A concurring opinion says, I agree with how you voted, but I have different reasons. And so I want to present my own legal reasons. So if Whitney writes the majority opinion, Lexi can sign her name to it. Like, you'll see which justices agree. So she can sign to the majority opinion, but she could also write a concurrence. And the concurrence is, here's my 2 cents. I want to add some other things to this. Sometimes the concurring opinion actually ends up historically being more important. Do you remember in our last unit when I had you look at those 3 court cases about presidential power? The one that had to do with Truman and taking over the steel mills, remember that? The concurring opinion from that case is actually historically more important because it was written so well and it did a really good job of classifying presidential power that it actually became a more important precedent down the line. Okay? I bet you can guess what dissenting opinion is. You're wrong. I disagree, and here's why. Dissenting opinions matter. Because remember, this is an ongoing process. So if somebody loses, that doesn't mean they typically give up the fight. Public policy keeps going and going. And if there is a strong dissent, that gives the losers some kind of like fuel to keep their fight going. Because they know that somehow, down the line, there were justices that were on their side. So like a 9-0 decision establishes it. This is what it is. A 5-4 decision certainly establishes policy, but it gives some people question. It kind of makes people go, it's not completely legit. I've still got some argument there. I've still got some fight in me. But a 5-4 decision certainly does establish. You can also concur to a dissent. So sometimes you'll have a dissent, and then you'll have a concurrence to a dissent. Okay? Our current Chief Justice, when he first came on board, he said, I want a lot of 9-0 decisions. I want a lot of us all on board. That has not happened. We continue to have multiple decisions and a lot of dissents for sure. And we have a lot of 5-4 votes. Well, before Scalia died, we had a lot of 5-4 votes. So we'll see what happens now. Okay? All right, stare decisis. Stare decisis is a really important judicial term. It is Latin for let the decision stand. Stare decisis, how a justice feels about that basically says, how do I feel about the decisions that my predecessors have made? How do I feel about this concept of precedent? See if I can give you an example. Okay, I'll give you an example in your real life. Okay, so Saturday morning, I was running around with Mia, and my older daughter was home with my husband, and he was making her do all of her chores Saturday morning, and she was mad because she's like, I have all day. I can do them when I want. He's like, get your work done so you can have a fun day. And she came and found me and proceeds to tell me all of this because she's trying to get me to tell her that she doesn't have to do them, right? And my answer was to her, your dad told you, that's what he said, you can't get me to go against that, right? Because I felt like he had already established a rule, and whether or not I agreed with him, I had respect for that, and I wasn't going to go against that. So then put that in context of a justice. There are decisions that have been made in the past. Some justices feel really strongly about not just simply like walking in and overturning those. The classic example that you can think about overturning that you guys know is Plessy versus Ferguson and Brown versus the Board of Education. What did they establish in Plessy versus Ferguson? separate but equal. So they said it was okay to have segregated facilities under the 14th Amendment so long as those facilities were equal. 60 years later, the court said they were wrong. And they said that separate is inherently unequal. Guys, that took them 60 years to make that decision. In the interim, there were justices who didn't like that decision. There were justices who would dissent, they would disagree, but eventually the court overturned themselves. Part of that is because of their slow. I'm not going to say they don't overturn themselves, they do. Sometimes they're like, whoop, totally messed up with that, okay? But the kind of decisions that a justice is going to make very much relates to how they feel about this and how do they feel about kind of tradition and what previous courts have decided. All right, a per curiam decision is an interesting beast. These are decisions where they only have a vote and they don't give us their legal reasoning. So there's no legal reasoning, it's just simply a vote. There is no precedential value in a per curiam decision. No one can use that to support themselves in the future, or a lower court judge can't use it as a guideline. Okay, Jack, why do you think a per curiam decision has no precedential value?
Well, it's not based off of a previous precedent that's set by any other justice.
Okay.
And it's kind of like, I wouldn't say random, but if they don't set their own precedent, then nobody can follow it.
Because what do you need for a precedent?
You need just like a historical example or a previous case.
You need words.
Decision.
You need a rule. You don't need a just because I said. You need a this is why. Because precedent is a rule to follow. Well, if I'm a lower court judge and I'm trying to follow a rule, I have to know what the rule is. I don't know why they did what they did. Per curiam decisions are not really common, but I'm just letting you know in case you encounter it. So they're not super common, but they definitely happen. Okay, so we want to look a little bit at the kind of things that cause justices to make certain kind of decisions. So what I want you guys to do is I made a bit.ly for you. If you go to this address right here, okay, and you got to type it exactly like it says, but if you go there, you're going to find the biographies of all the people who have sat on the Supreme Court. I'd like you to find somebody who's currently on, so you'll be able to tell. It'll say that they're still serving. And maybe if you guys, what you want to do is you want to split it up a little bit. So like one of you look at Thomas and one of you look at Kennedy, and please somebody look at Ginsburg because she's amazing. So just look at the different people and look at the stuff that you see. Look at their biographies, look at where they went to college. And I want us to try to come up with a list of the things that you think are important to the kind of decisions that these people will make. If they are impacting policy so greatly, we want to understand, well, what is it that's contributing to those kind of decisions? So we'll just take like 10 minutes and then we'll brainstorm and we'll see like a list of what's interesting about these people, like what's standing out about the factors that impact them.